Good evening, everybody. Welcome back for another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. We're back in the studio this week. I'm your host, Jimmy Ardwan. My co-host, Julio Vela. You're back as well. And we got our guest, Troy McKinney, this week.
With Troy McKinney to the left, good show. Period. Troy McKinney, ladies and gentlemen.
Where you been hiding out?
Me? So I'm having a girl.
Congratulations.
I'm having a girl. So we've been around.
About time you got the girl.
I know,
Yeah,
three
exactly.
boys and a girl. I don't know.
So is your wife finally done?
I'm done. We're all done. We're all done.
Girls are interesting, man. I have a 2-year-old girl, so I can tell you they are they're a little bit different than boys. Little bit.
Yes, they are. I had 2 of them.
They've got a little bit of an attitude about them. And yours is going to be the youngest of 4, so.
3 older brothers.
Yeah.
It'll be a good time.
Spoiled and protected.
Right. She's got her mob of protection.
Hey, look, so long as I can count on both of y'all as friends, colleagues, best lawyers I know, I'm good.
Well,
I'll be dead by the time she gets that.
we'll do what we can. But we're going to be with you for the next hour, ladies and gentlemen. We'll be talking about a lot of issues, local and national, in the criminal justice area. We'll open up the phone line. 713-807-1794 will be the number. We'll also take your questions and comments on Twitter at HCCLA_TV. And I hope you enjoyed. We ran the episode that we pre-taped over at the Houston Forensic Science Center Crime Lab. We ran that 2 weeks in a row. First week we kind of had a little issue, I know, with the feed, and it didn't pick up maybe till halfway through the program. So we reran it again last week for y'all, and I hope you enjoy it. We're going to have one more show with the fine people over at the Houston Forensic Science Center, and I really hope you're enjoying that series. It was a lot of fun to get out there and shoot it on the street in their building and get to see firearms tested and see the process for how we do it. We missed you. I mean,
I thought 2 hosts was too much.
Right.
I thought 2 was too much.
Yeah. I understand you had a busy schedule.
But when we have, on a nationally recognized scale, one of the best attorneys on the planet, and who's been recognized for his knowledge of science and academia in the entire country, Troy McKinney. Where were you at, man? Tell us about last week.
I don't know if all that's true, but it's sure like hearing it.
Well, tell us where you were last week, either in the East Coast.
Last week I was in Cambridge, Massachusetts for the National College for DUI Defense's summer program. It's a trial skills program for lawyers throughout the country, teaching them how to defend DWI cases. And I spent the week up there teaching.
How long?
I bet it went 103 degrees up there.
Actually, it was 90 with high humidity when I got there for the first couple of days until it rained me out on the golf course on Tuesday. And the rest of the week was work, but the rest of the week was high in the mid-70s and was spectacular.
How long have you been practicing law?
31 years and change.
So I'm 35. I was 3 years old when you started practicing law. Have you ever worked for the district attorney's office? Have you always been a defense lawyer? Either one of those?
I went to work for my current partner, Stanley Schneider, in March of 1985 as a law clerk. Went and spent a year at the Court of Appeals working for Justice Murray Cohen on the first Court of Appeals. And then Stanley hired me back at that point, and we've been together ever since.
You know, there's a story that you were the second highest score on the bar, not the first.
I've heard that story.
Either way, man. Jimmy, it's always a pleasure to be here with you and Troy McKinney, as always.
Well, I want to get into the big case going on this week over at the courthouse, and it wasn't at the courthouse because, first off, there is no courthouse for us to go to on a regular basis.
Federal courts think it's the courthouse.
Yeah. Well, no, I mean, I'm talking about state courthouse. This one was at the federal courthouse because of the lack of space to try cases and to bring in that many jurors for a capital case. And this would be the honor killings case of Ali Ersan.
Right.
Today he was found guilty after 45 minutes of deliberation, capital murder case. The issue in the case, of course, was that there were 2 killings of the spouses of his children. They were 11 months apart, and they were called honor killings.
There was also,
at least this is what the prosecution's theory is, of course, that they were honor killings. I think you got to go watch some of the trial.
now we tried to watch a bit, but there's also a killing of another Iranian
Right.
who was shot dead in her driveway, the Galleria area. Who was it? I think there was a lot of questions as to who did it, who done it, how they've done it. However, I'm concerned that maybe there was a lot of things that talked about, and the jury found him guilty on other things rather than that.
Well, that's what
issue.
That's what I want to talk about, because he was accused of orchestrating the whole thing, and there's suggestions, at least the defensive theory was that his oldest son may have been the one who actually committed the murders, and that his wife was also involved in the orchestration of the killings. Thus, you get this theory, if they're intertwined in a scheme, that it's capital murder.
Family affair.
Correct. Now, some interesting things happened. Of course, like I said, it was a capital case, and so they had to bring in a larger than normal jury panel, and that's why it was moved over to the federal courthouse. Given that our courthouse is out of commission, they needed the space in order to bring that many jurors over. And they've been doing this on any capital cases that have gone. They've been trying them over at the federal courthouse. But at some point this week, earlier this week, there was an incident, which is what I really want to focus on for purposes of our discussion about this trial, because I think it's probably what led to, as you and I were talking earlier, Troy, a very quick verdict in a capital case. There was an incident where at some point, I guess, Mr. Urson became very agitated and emotional, especially during the cross-examination of his son by the district attorney's office. At some point, the jurors in this case expressed to the bailiff and the judge that they were in fear not only for their safety, but for the safety of the prosecutors based on the emotional reactions of Mr. Urson. A mistrial was, of course, moved for. It was denied. After the jury had been let out of the room, Mr. Urson continues on this emotional path and shouts, "The prosecutors are devils," as he's being led out of the courtroom. That, to me, says, when the jury is expressing, hey, we're in fear of this guy, we're in fear of our own lives, we're in fear of the prosecutor's life, I think the presumption of innocence is kind of gone at that point. And we haven't even gotten to where he took the stand, testified, much less have it submitted to the jury. At that point, the presumption of innocence is supposed to carry all the way back to the jury room before they start deliberating.
What's the argument and what's the remedy?
Well, I will tell you, I did not follow this trial closely. In fact, almost not at all. When I first heard there was a 45-minute verdict, my initial reaction was that the jury must have believed that there was overwhelming evidence of guilt. That is an incredibly short deliberation on a 5-week trial.
Yeah.
It doesn't leave any possibility that any of the jurors, much less several of them, had any particular doubt. It doesn't leave much time for talking or deliberations. It pretty much suggests that there were very strong feelings to begin with, and it ended there until I heard about the outburst and the jurors' note. When I heard about those, I started wondering how much influence that had had. I don't know what procedures were followed to determine what the jurors had seen, what their reactions were, and more importantly, how they had talked about it. Obviously, if somebody talked to the bailiff or sent a note and expressed a community sentiment for the jury, they had to have had some discussions about that outburst or about just him in general, despite what I'm certain was the judge's repeated warnings not to begin talking about the case until the testimony was over. I know the judge denied the mistrial. I wasn't there. I didn't see the circumstances. I don't know what objections were made, but it certainly raises some questions, both as to whether they were able to continue with the presumption of innocence at that point, and more importantly, now that they're going to begin a punishment stage trial, they seem to have already concluded that he presents a future danger to society. I don't know how they can remain unbiased at that point after having expressed before the verdict that they thought at that moment he was a danger. This will be far from the last chapter written on this case if he gets the death penalty.
And so he testified. Does that have any impact on whether or not, let's say it was error. That the Court of Appeals could conclude that it was error for the judge not to grant the mistrial at that point when the jury expressed that. Does his testimony in any way, I know a lot of courts sometimes take the position that even if there is an error, that because the defendant testified and basically sunk his own ship in a lot of Court of Appeals opinions that we see, it's harmless error because the jury had the benefit of the defendant's testimony. I view this as a little bit different situation because here, like I said, you've almost got a situation where regardless of what he testified to, the jury's essentially thrown out the presumption of innocence before he even hits the stand.
Not just that, but even if there was overwhelming evidence of guilt, you still get to the punishment phase now where the jury has already told the judge that they feared for their own safety, specifically that he might commit a future act of violence, which is one of the questions they have to answer at the death penalty phase, whether he is likely to commit future acts of violence. And more importantly, as for the prosecutors. So they had to have seen things within the courtroom, perhaps beyond the outburst, to make them reach that conclusion. And when it comes to punishment, they're still required, they don't have to presume him innocent of the offense, but they still have to begin on a neutral playing field about whether it's life or death. Now, if they give him life, then obviously there's no harm to the punishment phase. If they give him death, then I think these issues will be revisited either on motion for new trial or perhaps on a post-conviction writ.
Oftentimes we hear certain groups coming into the courthouse wearing maybe T-shirts, free so-and-so or justice for such and such. When is the appropriate time to make an objection? Is there an objection available, and what's the remedy, in your opinion?
If someone walks into a courtroom with a shirt with a slogan that would have some impact or influence on the trial, the time to make that an issue is at the moment it happens or when you first see it. If you wait until afterwards, it's too late.
Is there something that within the rules that, I'd imagine if, let's say, even during jury selection, you have an individual coming in that's advertising, or maybe be an organized group or a charitable group advocating, or an advocacy group for a specific agenda, could that result in a mistrial or something that would be harmful to individuals seeking their trial?
Could it? Yes. Would it in all cases? Certainly not necessarily. It's going to depend on the nature of the case and the nature of what the statements or the image that's portrayed from the clothing or the material said. There's no way to draw a bright line and say this is and this isn't without knowing the underlying facts. But
you think if the jury were to, for example, in this Urson case, sent a note out saying, hey, look, we're scared. Whatever the note said, you think that would be an issue? Mistrial is denied.
In my opinion, the prudent thing to have done at that time would have been for the judge, with the presence of the lawyers and no one else, to have inquired of the jurors what it was that led them to that conclusion, whether they had any discussions, and then on top of that, whether any of them individually could continue to be a fair juror in the case before making a decision on the motion for mistrial. I don't know if that happened here. I seriously doubt that it did.
I've heard through the grapevine that this is the most expensive trial and group of trials, because keep in mind they have the father, the mother, the daughter, and the son, and maybe someone else that they're just hanging out there that hasn't been charged. It's all out of the 184th, if I'm not mistaken. Abigail Anastasio is the person who's running for that against Renee McGee. This is just one of this group, and apparently it's the most expensive trial in the history of Harris County, supposedly.
I would find that very hard to believe. There was, back in the 90s, there was a gentleman whose last name is Sims. I don't remember his first name. That case was tried, I forget, either 4 or 5 times before they finally got a guilty verdict at guilt. The first either 3 or 4, it was 4. It's the 5th time they got a guilty verdict. The first 4 were all hung juries, and I remember that very vividly because Chuck Rosenthal was the prosecutor, and he actually left my mother on either the 2nd or the 3rd jury, I forget. I actually within the past month or so, actually went back and read her and the defense's voir dire of her during that trial, which was kind of eerie to read.
I mean, to me, this whole issue with the fear underscores one of the things that we as lawyers talk about all the time with your clients is the jury's watching everything. And you really have to, as you're sitting there at the table, the mannerisms you make, everything you do, the jury, they're judging everything you do. They're not just judging the evidence. They're judging your mannerisms. They're judging the way you look at things. They're judging the faces that you make. They are picking up every little thing that you as the defendant do when you're sitting there as the accused.
Not having followed you are absolutely correct, but not having followed the trial itself and seeing merely the media pictures of him in the courtroom on other occasions, the image that was portrayed by his physical characteristics and his mannerisms were not particularly appealing. I can see there being some inherent prejudice in that to start with. I think you said earlier he's got some resemblance to pictures of Saddam Hussein.
He does. He does. He
that
absolutely
combined
does.
within some circles is a inherent bias against Muslims. I'm assuming this was a Muslim honor killing.
Right.
I didn't even know that for certain, but I don't know if he was cleaned up for trial in any way, but as much as you tell somebody you need to sit there, be respectful, be quiet, be silent, you can't always control that. People are going to do what they're going to do, and defendants in trials are no different. I tried a capital case in 1992 where during the cross-examination of the state's key witness, my client bursted out, quit lying. It happens.
Yeah.
It happens. And the jury does pick up on what they see, what they hear from the defense table.
So, have you ever made an objection to it being a fair cross-section of the community in a sense of, okay, so here in Harris County, we get a jury panel, and sometimes you'll get one Hispanic, one Black, two Asians, and somebody who doesn't identify out of 24 or 60, depending on where you're at.
Have I ever made the objection? Yes. Unfortunately, the law in this country is very clear from the Supreme Court to the Court of Criminal Appeals that you're not entitled to, for those who don't know, there's, at least in Harris County, they bring 2,000 people over to the jury room from which they then pull panels of, depending on the kind of the case, anywhere from 20 to 150 people for a particular trial. And those 20 to 150 are selected randomly from the 2,000. The law does not guarantee you, and it is not a valid objection to say that the 20 to 150 that you get for your case represent a cross-section of the community. What the law says is that the method by which they get those 2,000 people down there is not structurally such that it excludes identifiable groups, whether it's minorities or race or ethnicity or gender.
Right.
So long as the method of calling them for jury selection is neutral and not inherently discriminatory in effect, and so long as the method of picking from that big pool for the pool that goes to the courtroom is the same way, then it is not a valid objection, and never has been, to say that the people you get in the courtroom on an individual case don't represent the community at large.
Rumor on the street is they're opening new felony courtrooms. That's the rumor. That in 2 or 3 weeks they're going to be opening courtrooms for felony trials because the backlog of felony trials is getting to a point of where they need to do something. Have you heard anything about it? Have you heard anything about the backlog? And who's going to be presiding over these new felony courts, if you've heard anything?
Well, I don't know they're new felony courts.
Well, courtrooms.
Trial space.
Some courtrooms, and I haven't heard the rumors. I've been basically out of town for the last 2 weeks.
Right, getting the award. The man's the best in the country.
Away from all this crap. I mean,
right.
The latest is they're going to open they plan to reopen the CJC April of 2020, even though, and it's going to cost $86 million is the official.
I did see the media report on that. Well, and I'll tell you when I heard that, at least the media report, I haven't looked at the documentation behind it, was that the final piece of whatever they were going to do was going to be in April 2020. What I did not know and could not tell from that report was whether the courthouse would be open prior to that final piece.
Yeah. which, as we all know, since they haven't even done a bid, means probably April of 2021, and it's going to way exceed $86 million.
It has created a huge backlog in the courts.
Yeah.
Both the felony courts and the misdemeanor courts. I've got a trial setting next Friday where there are more jail cases set for trial than there are bond cases set for trial, and the jail cases are, for the most part, older than most of the bond cases. I don't know which case is going to trial, whether mine is or anybody else's is, but the jail cases, the people who are sitting in jail waiting for their trials, they need to get their trials long before the people on bail do. Mm-hmm. And keeping them there without a trial, there are alternatives, as occurred in this case by taking them over to the federal courthouse. Now that they've opened up the top 4 floors of the Criminal Justice Center for incarcerated non-trial settings, frankly, the incarcerated trial settings are probably more important structurally than the incarcerated non-trial settings.
Well, and I don't mean this to be a comment on which way anybody should vote or anything like that, but you have to also realize that we're coming up on a November election that could, who knows which way it's going to go. And if a lot of judges are gone after November, guess what? There's going to be at least 90 days that some of these courts aren't going to have a trial because
They gone.
Every single one of those judges has to go to judges school before they can conduct
They
a trial.
gone.
All 16 of the county courts, no, 15 of the 16 county courts are up for election this year. Of the 22 district courts, roughly half, it may be exactly half, are up for election. Some of those are open benches. Some of those, all of them are opposed. They've all got candidates in both parties. If there are 20 some odd new judges in Harris County, if the Democrats sweep and there's 20 some odd new judges, there's going to be a breaking in period because the people who have not been judges before, some of the candidates don't really have a lot of experience in the criminal courthouse. It's going to slow things down. For those who, if there is not a bunch of turnover in the judges, then trials will continue on as normal, although I shouldn't say as normal.
Right.
Or as normal under our current abnormal circumstances.
Right. Yeah, so...
I would say, so the last 2 trials that I've been in the last 2 weeks on the misdemeanor side have been with judges I've never seen. So not Judge Hancock, not Judge Anderson, not the wonderful judge from Harvard. What's her name? It escapes me at the moment. Not any of the regular judges, but some of these old school judges. The last 2 trials have been really amazing. Really good defense rulings, really good, not even defense rulings, just rulings on the law. A lot of them have been civil judges. The last 2 were actually civil judges. One of the judges told me she hadn't tried a criminal case in 20 years. It provided for real, what I would say old school, even though I don't know what old school means, kind of trial where the defense and the defendant wears their white hat. Vordar.
I've never seen that kind of thing in Harris County.
It was amazing. It was amazing.
That was certainly not old school in the 80s and 90s.
No.
Not at all.
No, it was great. But there is a massive backlog for trials. I'm setting misdemeanor trials for June 2019 now.
That's just crazy.
June 2019, dude.
That's just crazy to me. I want to remind everyone, if you want to get on the conversation, 713-807-1794 is the number. Also, hit us up on Twitter at HCCLA_TV. I want to change the subject, switch topics here, go national. Before we get into talking about some constitutional stuff with you, I want to focus on the case that's getting ready to go to trial here. The first special counsel case, that of Paul Manafort. Regardless of what your politics are, whether you believe Manafort is good for this, if you hate him, you love him, whether you're a Trumpian, a never Trumpian, whatever, I want to focus on the procedural things that are going on here. Manafort is indicted in 2 different districts. He made the choice not to have the cases consolidated. And so the case in Virginia is the one that is first up. The government there has been 140,000 pages produced in 7 different discovery productions by the government. Now, he did not waive speedy trial, and in federal court you have a right to a speedy trial within 70 days of the date of your arrest or indictment, whichever occurs first. Actually, it's on the appearance on the indictment, I'm sorry. But there are ways to extend that deadline, what they call excludable delay. We've had a little bit of that in this case because of production, because of him being moved, lack of being able to consult with his counsel after he got his bond revoked and thrown in jail. But what happened about 6 weeks ago is the government, actually not even 6 weeks ago, 2 weeks ago, July 6th, 19 days before the scheduled start of the trial date, which was supposed to start this Monday, the government dumped more than 50,000 documents on the defense. Okay? They were documents from Rick Gates, who is a cooperating witness in this investigation, from his electronic devices. This is stuff they've had for a while. And they decide 19 days before the trial to dump it in a batch on the defense. Defense is, of course, they're going to move for a continuance. The judge gives them 6 extra days to review that. There's almost a little bit of the judge kind of feels the defense is playing games with him. I'm sure the defense could have handled this a little better from what I've been reading. But at the end of the day, this kind of thing, I don't think a lot of people understand. This happens so often in federal cases, this rolling discovery that prosecutors have. It happens in state court cases too. But it really, because state court cases don't have the volume of documents, particularly that federal white-collar cases do, this happens so often in federal white-collar cases where on the eve of trial, you'll just get dumped with a bunch of stuff. And you're expected to go through it and be ready for trial. I mean, Troy, in your eyes, what's the appropriate remedy for this, and how should a defense lawyer handle? Because I think we've seen a lot of missteps by Manafort's team here. What do you think would have been the appropriate way to handle this stuff?
The first appropriate way to handle it was for that stuff to have been produced a long time ago. When it's produced on the eve of trial or within a couple of weeks of trial, the judge has several options. The judge can continue the trial and say, okay, we're going to reset it for a week or a month or a year or whatever is necessary to give the defense time they need to prepare. The judge can say, you know what, it's too late. None of that's coming into evidence. The ruling that none of it's coming into evidence only solves part of the problem if in that big data dump there are documents that are useful to the defense. The Brady Doctrine, federal constitutional law, and statutory law in almost every state requires the state to produce to the defense documents that will help the defense, called exculpatory evidence, that in sufficiently far in advance of trial to enable them to be able to use it effectively at trial. We have all seen data dumps where the government knows there is something within the material that will help the defense, but rather than cull that out separately and say, here are the things we think you might think are exculpatory, even though we don't confess that it is, and here's all this other stuff. Instead, the government says, you know what, we're just going to give you everything, lump it all together, and let you go sort through it. Judges have ways to remedy that if they're so inclined to do so. If the government's risk on this is if they do this big data dump and the time is not sufficient to go through it, and a conviction results and things that are helpful to the defense are found afterwards, then they may get to try the case again. And it wastes everybody's time, it wastes the resources of both the government, taxpayers' money, as well as the defense time. It's simply not the way to run a courthouse. The flip side of this, and the problem on this case, is that in most federal cases, the defense, if not expressly waives speedy trial, does it effectively through their motions and the delays that are accompanied by that. If Manafort, given that he hasn't waived a speedy trial and apparently hasn't done things to delay it sufficiently, then he's boxed himself into a corner where he has a choice of either saying, hey, we need more time, where the delay's arguably on him.
Correct.
Or whether ultimately an appellate court's going to say, no, that delay is not attributable to him, speedy trial's run, the government should have done this sooner, and he may ultimately get a reversal or either a dismissal in the trial court later on or a reversal on appeal for that.
Yeah, that's the interesting thing. I mean, it's just, what is the strategy here? I mean, and some of the prosecution has said, of course, look, we've produced everything that we thought was relevant. This was just an abundance of caution, as you said before. You know, that's their response. We're just giving this over to you in abundance of caution. We don't think it's relevant. But the other thing that they kind of argued was that they felt that Manafort's legal team was playing games because they've always wanted the D.C. case to go before the Virginia case, and that this was just a way for them to try and drag out the Virginia case so the D.C. case could be tried first. The judge may or may not believe that. I mean, he may. I mean, clearly I think that the judge is getting a little frustrated with both the special counsel's office and the defense team on this case, but more so, he made some very pointed remarks at the defense team about how this case should be tried. And we're not going to go into, you know, the Trump campaign and you know, what's going on in the presidency and that sort of stuff. We're going to stick to what he's been charged with, you know, and that's this whole Ukrainian issue that's out there, lobbying on behalf of a Ukrainian company.
What's the guidelines on? Oh, go for it.
If I'm the defense on this case,
yeah.
I'm going to make an effort at this point to find things that are within this data dump that are either inculpatory, harmful,
right,
and obviously relevant if they are, or are exculpatory. And all you got to do is find a few to go back and say, look, we've only been through the first 1,000 pages, 2,000, 5,000 pages, and this is what we found. So the government's representation to you, Judge, that none of this is relevant was a lie, it was a false statement, it was a misrepresentation. Right. And then you get some meat on the bone on we're not the ones playing games, it's the other side.
Now the good news is, I mean, I've done the math. If what they're saying is true, if you looked at each document for about 8 seconds, it'd take you about 150, 160 hours to go through it. You know, so some associate at one of those big firms that's working on Manafort's case is gonna be able to make their billable hours
for the month.
But here's the problem. This is the practical problem. Yeah. Even if an associate or some other lawyer is able to go through it,
it's the trial lawyer who has to put their hand on it.
Some decision about what they think is relevant or not relevant or important or not important, even if it's all relevant, the trial lawyer still has to. Number one, trial lawyer is responsible for that decision.
Yep.
Number two, the trial lawyer still has to be able to take whatever they find after that 150 or 160 hours, digest it, and incorporate it into the case.
Well, and this is while the lawyers who are trying the case are getting ready for trial, getting ready for voir dire, preparing their voir dire questions if the judge is going to allow it. I know there's a questionnaire that's going to be allowed. Preparing opening statement, preparing their witness questions, preparing their outlines, you know, the exhibits that they are going to use, what they're going to cross-examine the witnesses on, which documents. And now you get 50,000 additional documents that you're going to have to trust your associate to make the initial run-through, to then bring it to you. I mean,
never.
160 hours would be basically 4 weeks of doing nothing but this, 5 days a week, 40 hours.
The trial's going to be over by the time they get through it.
I don't know that anybody, unless there's a bunch of duplicates in that, or there truly is huge stuff that you can just flip page by page because you know it has no connection to anything.
Yep.
I find it hard to believe that could be done in 4 weeks on 50,000 pages.
I do too. And the other thing is, most of this stuff, when you get it, it's not in a format that you can just dump it into a search engine, and it's not OCR'd. I mean, the way, I think this is one of the most frustrating things that a lot of people don't realize what the government does when they are producing documents to lawyers in these big cases. What they do is they do not OCR a damn thing. They don't Bates label it, they don't OCR it. If you're lucky, they might put it in some folders just because that's the way the FBI organized it and gave it to them. But then they put it in this encryption format, okay? And so it comes with a password. If you run your computer if you run your office on a Mac, odds are you're not going to be able to open it because it's a Windows-based program, because the government has a contract with McAfee or whoever their encryption service is. So you're going to have to go out and get a Windows computer to open it on. A lot of times these things have viruses on them that you run the risk of opening up. And even when you do open them up, a lot of times the government will say, well, here's the drive. We're providing you the drive so you can copy it, but you need to give it back to us because it's our property, okay? And so you do that, and you get a drive, and you plug it in, and you start trying to move the folders on. You move the first folder over, and you're looking at it, and it says, it'll take 27 hours to transfer the first folder over.
Right.
You're like,
Right.
Because they've given you a drive that has a USB 1.0 port instead of a USB 3.0 port, so the transfer speed.
Right.
I mean, they're just jacking with you on so many different levels.
Some of that, I don't doubt that there are cases where they are intentionally jacking.
Oh,
people.
absolutely.
I think there are others where they are just behind technologically.
No doubt.
That much that they're just simply passing on what they get. They're not going and buying that new hard drive,
No.
the new USB or whatever it is they'll transfer this data quickly.
Yeah. They are not. They're not the latest and greatest technology. That's for sure.
This whole dump thing is maybe a symptom of a larger problem. We heard in the news, DeToto's case, they dumped, 10,000 pages of medical records in the middle of some sort of proceeding, and the question is he supposed to go forth to trial even though he found something that is probably exculpatory and should have been investigated and should have been brought to his attention? I mean, that's all over the news right now too. I think this whole dump thing is a symptom of a much larger problem.
There was kind of the nuclear option on this for a lawyer there was a lawyer in Dallas, a guy named Chris Hoover, on a trial where he went in and his expert was not available.
Mm-hmm.
They had told everybody in advance, and the morning of trial, the judge says, tough, you're going to trial without your expert. And he took the nuclear option, and he said, you know what, you can make me sit here, you can't make me participate, and I'm not going to participate. And he sat through the entire trial, didn't say a word, every time he was told it was his turn, he said, we're not participating. And obviously the trial turned into a bad verdict for his client. It was a little misdemeanor case.
Yeah.
His client did not go to jail immediately. Ultimately, the Court of Criminal Appeals reversed that case. And that decision has been used rarely,
Right.
but sometimes very effectively, to say, you know what, given the circumstances here, I'm just not going to participate. It is the nuclear option. It's very easy to do on a misdemeanor case where there's going to be an appeal bond, where somebody's not going to sit in custody. That's not so easy to do on a felony case where...
Or a federal case.
Or a federal case. Federal judges might take a far different view of that.
Yeah. You might be going to the FTC with your client.
I don't think there's any question. But I don't think the judge can order you to do any particular thing during trial.
Yeah, I mean,
Now, in federal court, they will immediately disbar you from the district.
Yeah, no, well, that's for sure. But I mean, and like here in the Eastern District of Virginia, where the first case is going to go to trial, that's known across the country as a rocket docket. I mean, that district gets criminal cases to trial faster than any other district in the country. And in most districts, it kind of varies by which judge you get. I mean, here in the Southern District, some judges move their docket faster than others.
Were you ever in Janice Jack's court in Corpus?
Yes. Yes.
Ultra rocket docket.
Right. So, I mean, but a lot of the judges are becoming, I think, more aware of, especially if you are a lawyer who deals with a lot of these cases. I mean, there's just no way to manage that kind of docket. I mean, you get a case that has 200,000, 300,000, a million, or as in the case that I got the other day, 15 million documents. I mean, that you can't try that case in a year.
No.
It's going to take you a while just to get through the discovery to figure out what the relevant information is.
It's going to take a long time just to figure out how to categorize in broad scopes what you have. One of the disadvantages for defendants in federal court is that most of the time, not all the time, but most of the time, especially on the white collar cases, the government has spent weeks to months to years gathering evidence, reviewing it, collecting it, organizing it for themselves, and then the indictment happens.
Yep.
It's not like they're busting a drug dealer on the street and the case starts at that moment for everybody, which also rarely happens in federal court.
Yeah.
But they've had most of the time months to years building their case, and then all of a sudden, there's defense can request a quick trial in those cases.
They can.
But there's no way they're going to be able to spend the kind of time the government had on the front end if they want that quick trial.
It is the very rare white collar case that you can actually not waive speedy trial, go to trial in 70 days, and have it be a good result for your client, I think.
Or not put yourself for the lawyer, put
Yeah.
yourself in a position where you're going to almost assure a finding of ineffective assistance down the road.
Right, exactly.
Yes, right.
I mean, because if you haven't looked at the documents, how can
Right.
you sit
I
there
mean,
and say,
right. I mean,
"You're gonna try the case?"
the longest trial I've ever been in my entire life, and I try cases nowhere near as either of you. However, the longest I've ever been in trial is 6 days. 6 full days. 12 hours. 6 days. What about y'all?
I spent 10 weeks in a trial.
10 weeks? Are you serious?
6 weeks, death penalty case, 6 weeks of jury selection, 4 weeks in trial.
Here?
1992 in Harris County.
Who'd you try it with?
Tom Moran and against Casey, no, not Casey, that was Holloway. Hawkins.
Wow.
And,
Wow.
shoot, I'm drawing a blank.
Do you remember what courthouse? Where was this at? I mean, was
It
it
was in the old.
where the appellate court is now or the juvenile?
Oh, no, where the juvenile court is.
Really?
Yeah, we spent 6 weeks in jury selection, 4 weeks in trial.
How about you?
I've had multiple 6, 7, and 8 week federal trials. I had a 7-week federal trial a couple years ago.
What do you do with your practice?
It shuts down.
You get enough money. I call those practice killers.
Yeah.
You got to make sure you get enough money, not just to cover for the time you're there, but for the time you aren't getting new cases during
Right.
the pretrial stage, the trial stage.
Now, in the last one that I tried a couple years ago, it went 7 weeks, but we did have Fridays off because the judge had to run her regular docket on Fridays.
Was it Dallas or
It
here?
was here. So, but I mean, that's, some of these cases, they just take a long time. I mean, I think I'm going to have another 6-week one coming up. When you've got 1,000 exhibits, they're document intensive, and the government is bringing sometimes 20, 30 witnesses. It's going to take a while.
How do you do
There was a multi-defendant, I think they had 10, maybe 15 defendants on a federal trial in Hittner's court that I substituted in, or I sat in for 2 days that lasted 8 or 9 weeks.
Mm-hmm. Yeah.
It's a different experience. And lawyers have restraints on how they can ethically set fees. One of the factors is that you can charge more in a situation where you're losing the opportunity to take other business. And that can be a factor in considering that what might otherwise be an unreasonable fee is in fact reasonable because of all the other business you're giving up. These long trials, that factors in prominently.
That would be, I guess it could be anything from an aggravated sexual assault to an ag rob to a murder to a RICO.
Big difference between that first category of cases and the last category.
Well, how? Hold on, how though?
Because of
Documents.
the volume of documents, the number of witnesses.
Yeah, just when you have an assault case, you usually have an offense report, some labs, maybe some photos,
Right.
and that's it. In a RICO case or a money laundering case, you're going to have the bank records. You might have emails. You might have text messages. You might have, all sorts of other kinds of documents that they're going to seek to be admitted to show the scheme or how things are played out and show the records. It just gets to the point. Like I said, that last case that I tried a couple years ago that went 7 weeks, we had 1,000 exhibits. 1,000. It was all about, and that was what the government sought. It was a case that had thousands of other documents that could have been admitted because that was just the exhibits on the 30 counts that were charged in the indictment. You had loan files, you had all the applications, you had all the paperwork.
Is this the mortgage fraud one?
Right.
I saw this.
So you got the loan app, you got all their supporting docs in each one. So it just goes on and on and on.
I will say, I think Jimmy, respectfully, I don't have to blow your head up because I love you anyways.
Anyway.
The mastery of you were going through documents and you would touch and it would come up and it would be on the big screen and you'd touch down and you'd swipe, highlight, boom, touch. I think you're on the the next level as far as where technology in the courtroom needs to go. It almost seemed like the technology in the courtroom was behind what you could do.
It was because I actually was using this, and because it would not hook up properly. And so I was actually at one point having to use this on the Elmo machine.
I remember that. I remember.
Because the connection to the court's computer system kept failing. And I had all the exhibits loaded onto my iPad to be into a program where I could highlight and pull it out. And that's why I say, lawyers who want to try these white collar cases and really want to get into them, you have to know the documents. You have to know where the key elements. I mean, you've got a bank, a 50-page bank loan document. You need to know what is said in this clause, and this clause, and this clause, because it's the fine print that can be the difference maker in walking your client out of there and having him go to prison for 20 years.
Well, I remember he would do this thing. It's in the real big courtroom, the big one, and you have a 20-foot widescreen. And he said, "Look," and one of the key things in the case was who signed on the documents.
Right.
And he would just click up, and then suddenly you have a 15 foot kind of image, and he would circle and be like, "That's not my client's signature," or something. And I thought it was very effective.
There are many cases that are document intensive where one side or the other's team has non-lawyers dedicated simply to running the electronic equipment for document presentation.
Yep.
It's gotten to the point where you can spend tens of thousands to hundreds of thousands of dollars during a lengthy trial on nothing but taking all these documents, getting them in electronic format, indexing them, searching them, making them presentable at trial, and having one or more people have to learn what they are, where to find them, so that you can get them on the fly during trial.
Yeah.
Unlike the old days when the courtrooms had no technology, where defense lawyers were going out and buying their own
blow-ups,
their own projectors, fold-out screens,
Right.
and that still happens. I've sat in a trial in Victoria that Chris Tritico tried, and I was going to testify as an expert, where the AG's office brought their own projector, brought their own screen, and this was within the last couple of years. That was the old school way. If you didn't have the projector, then you were back to the days of having nothing but the poster boards and writing it on a chart and flipping 50 pages of charts.
Jeez.
Do you think that the technology is good, or you think you're more old school? What are your thoughts on where it's going?
Technology is good if it's done right.
Sure.
But that doesn't mean that there are not situations where we're having a flip chart where you can write things down as it happens aren't also good. I did a demonstration cross up at Cambridge at Harvard Law School last week that, because of the time limits, I didn't have the time to do what I'd normally do and go write the stuff on the board for the jury. So instead I had a PowerPoint prepared, which is easy on demonstration because it doesn't matter if it matches perfectly. It's hard to do in the courtroom unless you've got somebody else actually typing in the words of what the witness said, popping it up on a slide at that moment for the jury.
Well, if you've ever sat through a CLE of Troy, everybody at the end is, "Can you just download it to a thumb? I need a thumb drive," because that is just you're just writing, because everything makes sense. Everything makes sense that you say, and you're just writing on a legal pad, and you're at the end, you're like, I just have to listen. And please download all your stuff on the thumb drive at the end.
Next time I want an ego boost, I'm just going to call you.
I'm telling you, man.
It makes you feel great.
I'm telling you.
While we got you here, I want to pick your brain on some of the stuff that happened this week since we talked about Manafort, all the things that are going on with Team Trump. We've heard now the tape.
Did you hear Rudy Giuliani's response?
Tape. Yeah, I did. First off, let's talk about a lawyer taping his client. I mean, the obvious is it's really, while it may be legal in a one-party consent state, it's probably not ethical.
Here's the bottom line. It certainly is. It's not unethical unless it is done for an improper purpose, unless the client asks if you're taping and you don't disclose it, or if you intend to use it offensively for something. Most taping occurs, and this applies to lawyers and everybody else, most taping occurs for purposes, for what I call defensive purposes, to prevent someone else from coming back later and saying, during this conversation, you threatened me, you cussed at me, you intimidated me. That's the only reason that it prevents other people from lying.
Right.
My sense is, and lawyers tape other lawyers too.
For sure.
My sense, my My practice has always been, my belief has always been, if you are taping for the purpose of defending yourself against false allegations, then that is fair game. It doesn't matter whether it's a client or anybody else. I won't say I've never taped a client, but it's an extremely rare thing, and it's always done to protect from an allegation that something nefarious had taken place during the conversation. If you're taping it to use it offensively, if it comes to a client or another lawyer, neither one of those are necessarily unethical, depending on the circumstances, but it's bad form to me. In my opinion, it's unprofessional. There are lawyers in town we all know, who I won't name here, who have reputations for taping every conversation. And you simply watch what you say with them.
Yeah.
The only times I tape are when I am concerned about a lawyer or somebody else misrepresenting what was said,
Sure.
or claiming that I said something that was unethical or illegal.
Yeah, I don't think I've ever taped a client. I mean, I certainly have taped other people, but I don't think I've ever taped a conversation with a client. What about the whole raid on a lawyer's office? How do you view that? I mean, obviously, there seems to be justification for it.
There was a great deal of complaint among lawyers on how can you do this. There were people, and obviously Trump complained about it. There were people, general public, who complained about it. Said, how can this possibly be? At the time that took place, and all the press that happened from the raid on Cohen's office, there were in Texas at least 3 cases pending against lawyers I know of, and probably others, where their offices were raided, where their houses were raided. Because in each of those instances, there are search warrants, where a judge has reviewed whatever evidence the government presented and has determined there's probable cause to believe that there's going to be evidence of some crime found there. Whether there is or isn't, whether the warrants were justified or not, gets decided later down the road. Well,
and the other issue too, in a federal investigation like that, and I would assume on the state side as well, there's a lot higher scrutiny too, of before we go get the warrant, somebody within a higher level of the Department of Justice has to sign off on us going and get the warrant, and essentially initiating
somebody at Rod Rosenstein's level.
Correct. Yeah.
It is very high up in the Justice Department. It's less common in Texas, very common in Florida.
Interesting.
Florida defense lawyers, for as long as I've been a lawyer, there have been more lawyers who have had search warrants run, who have had Title III wiretaps put on their phones, who have been prosecuted than any place else in the country. That may be partly a product of all the drug cases in and running through Florida.
And probably a much more aggressive prosecutor's office.
And a much more aggressive U.S. Attorney's office.
Are they known for that?
Yeah, I mean, look, some districts are a lot more aggressive than others. There's a lot of other districts that are more aggressive on having what we call nebia hearings to determine what the source of your fees are and taking your fees.
So I've heard of that. So there's nebia hearing. They say what's the source of your fees, how'd you get paid, and such, and they're getting it from Title III wiretaps.
They could, or I mean, they think that you got paid in funds that were illegally obtained, and so they're going to try and claw it back.
Yeah, they're going to come back and say that, and I'm just making up this number, this $100,000 you got. If that's products of drug dealing or product of any other criminal activity, guess what? We're going to seize it, and you got to pay all that money to the government. And that may be early on in the case. It may be after the case is over and you've done all the work, and then you're just out of luck for your fee.
That's terrible.
You know, one of the things, Troy, that some of the national media has, and these legal analysts on the big stations have pontificated about, is Manafort perhaps, and not so much Cohen anymore, I guess, but specifically Manafort angling for a pardon. And that maybe that's part of his strategy here, to get the trial quickly, get it over with, and then get his pardon from the president. Do you think that is what his strategy is? Do you think it's likely to happen? And then we've heard about this. We've heard Trump himself say he thinks, and his lawyer Rudy Giuliani, they think they can pardon himself. I mean, is that even possible?
There are no restrictions in the Constitution on the president's pardon power. The only way to know whether a president can pardon himself is for a president to attempt to do so, and more importantly, for somebody to then have standing to challenge it.
Who would have standing to challenge it?
Excuse me, I thought about that before, and I'm not sure who would have standing to challenge it. Maybe somebody in an underlying civil suit where the lack of a pardon mattered to like criminal activity in some way. It'd be very rare to find somebody who could actually have standing. I suspect that the Supreme Court might ultimately find that whether to pardon or not, whether the president can pardon himself may ultimately be a political question.
That's a very interesting thing. Because
right?
because that takes it out of the courts.
Right,
entirely.
correct.
It does.
Then it becomes an issue for Congress
or it becomes an issue for the voters, or for Congress on impeachment.
Right.
And that's the same theory. I know there's an ongoing debate about whether a sitting president can be indicted, much less prosecuted, while they're in office. I've read lots of very learned articles on both sides of that. There are lots of legal arguments on both sides. There are even more compelling policy arguments, one way or the other. The most compelling argument for it is that, look, presidents, like everyone else, are not above the law. The most compelling argument on the other side, from a policy standpoint, in my view, is the Constitution provides a remedy and says it's impeachment. The Constitution, the system of federal government would break down. We would not have someone in office who could effectively perform the powers of the presidency, both domestically and with respect to foreign relations. It might compromise national security in the process. There are compelling arguments on both sides. The arguments against it that are based on policy, my response to those has always been, that's what we have the 25th Amendment for, where if the president is unable to perform his duties for any reason, then the cabinet can remove him and appoint the vice president or someone else down the line if the vice president's not qualified.
That's phenomenal.
But we'll never know the answer to those questions unless and until one of the events happens.
That's phenomenal.
There's always a first time.
Oh, I hope there's not a first time.
There's certainly been a lot of first times in the last 18 months.
Yes, there has. We got about 30 seconds left. What do you think we're going to see here with Manafort, just quickly?
I don't know the merits of the underlying case. I think this was the first one the government brought. I think they believe, in this case, probably more than most of the others at this point. This may be an effort to put pressure on Manafort to provide other information that he so far has not been willing to do. I wouldn't want to be in Manafort's shoes because the government's been over the top aggressive with him.
Well, and one of those prosecutors, Andrew Weissman, has a reputation for making witnesses talk at some point down the road. But that's all the time we have for this week, Troy. Julio, I appreciate you joining us this week. It's been fascinating. It's always good to have you on because you make us smarter.
It's a great show. It's a great show.
It's a
great
Happy
show.
to be here. Always like coming to this.
Yeah.
And schedule permitting, I'm always willing to do it.
Well, we appreciate it. That's all the time we have for this week's show, ladies and gentlemen. We'll be back next week with another edition of Reasonable Doubt. For Troy McKinney and my co-host Julio Vela, good night. We'll see you next week.
It's awesome.